Joining us right now is criminal defense attorney Joanna Nieves. And Ms. Nieves, the Utah County attorney seemed to bend over backwards today to remind reporters that in this country, despite any evidence, the defendant is presumed innocent. Are you concerned as a criminal defense attorney about the level of information that has already come out publicly from the FBI?
Good afternoon, Del. Thanks so much for having me. I think everybody has a fair level of concern when it comes to high-profile cases like this, and whether or not the information that's released will ultimately impact a jury if this ever got to a jury phase. Ensuring that the client or the person accused of the crime is given the fair trial that they have the right to have. However, the court and counsel are typically familiar with processes that can be put in place and mechanisms that can be used to limit the effects that this type of commentary has on the outcome of a case, whether that's gag orders or curative instructions, limiting access to the media. There are things that can be done to limit the impact, where we focus on the evidence versus the commentary.
Ms. Nieves, what is the difference between press accounts, for instance, the Washington Post, saying that they have seen texts that would seem to indicate that Robinson has actually confessed, in the words from the FBI director?
I think one thing that we can rely on is that in the information that the county attorney read from, he indicated some of the texts that were used in making the charging decision, and they did reflect certain admissions. They did reflect communications with the roommate indicating, yes, I left a note behind and I had an opportunity to kill Charlie Kirk, and when directly asked about it, are you the person who did this, he said, I am. So I think that there is a level of corroboration to whether or not these admissions exist, and the commentary from his parents about comments that he made to them implying his involvement in the murder.
Ms. Nieves, you know, as a criminal defense attorney, that all sides work together on these cases. The county sheriff, the local police, the university police, they bend over backwards to make sure that they give each other credit. Is this a situation where the FBI director is simply bigfooting?
I do believe that there may have been a lot more information released at the outset while an investigation is still taking place. I do think that in any case where a prosecutor is making a decision about how to charge a case, they'd rather keep cards close to their chest, right? So that they have the ability to pursue an investigation and direct law enforcement in a way that can help them secure a conviction and limit the taint that may occur if too much is released too soon. I think that it's better to be a bit more measured and judicious with what's put out there at first, to ensure a fair trial to begin with, but also to ensure that an investigation can proceed without it being obstructed or tainted in any way.
If you were a criminal defense attorney representing Tyler Robinson, would you think he can get a fair trial?
I think ultimately we have to take into consideration the fact that this was a murder that took place in front of 3,000 plus people in a very public forum, with a person who had a polarizing and influential and viral type of presence that is gaining the attention of the media and his following that he had. And so I do think that there would be concerns about whether or not there could be a fair trial, but I do also know that there are tools that can be put in place to limit the impact that commentary can have on a jury, whether that's weeding people out during voir dire about their biases, or, as mentioned before, media limitations and gag orders, or even a change of venue. But I do think that the highly sensationalized aspect of this can have an impact on on getting an impartial jury if it gets that far.
If this is such a high-profile case, does it matter? Because anyone who hasn't heard of this case right now, it would be safe to assume they are living under a rock.
Absolutely. I mean, from lay people to people in government offices, they're talking about it. The day and age that we live in, I think news spreads like wildfire. You would really have to have no social media presence, or, never turn on the television, never turn on the radio. It's something that is being talked about. It's expected that this is going to be is widely publicized, and the expectation that we're going to get jurors who've never heard of this is probably slim to none. However, can that juror articulate that they're willing to put anything that they've heard aside, not bring anything that was stated out of court into court, and not consider it as evidence, and make a fair and impartial decision?
Ms. Nieves, final question before I let you go. Utah's Governor Spencer Cox saying he believes that social media is a cancer, his words. Do you believe that social media has made your job as a criminal defense attorney more difficult?
Absolutely. I think one of the things as a criminal defense attorney we always talk about is don't say anything. Don't talk to anyone. Let us do the talking for you. And the difficulty is everybody is posting what they're doing, posting their whereabouts. Right now, digital evidence is the new DNA. There's DNA evidence in this case, but text messages and locations and pattern of life, the social media posts and the way that people carry themselves are so accessible that it does make the case a bit more difficult to handle.
Criminal defense attorney Joanna Nieves. Ms. Nieves, thanks for being with us today.
Thank you.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.